lawfare. Thank you, Mr. Chairman.
I thank the gentleman from North Carolina. I'll now recognize the gentlelady from Washington for 5 minutes.
Thank you, Mr. Chairman. President Trump has a long and documented history of attacking the judiciary simply for following the law. He once suggested that a judge who granted class certification in a fraud case against Trump University could not be impartial because the judge was of Mexican descent. He called other judges, quote, crooked, corrupt, and evil. And most recently, he refused to comply with judicial orders, blocking the implementation of his unlawful funding freeze. My colleagues on the other side have unfortunately endorsed this behavior, and now they propose legislation that would further empower President Trump to evade accountability in the courts. Professor Besky, what effect does this kind of behavior towards the judiciary have on the integrity of the court system? Just briefly.
Well, it takes us into dangerous territory. I mean, the whole premise of Article 3 judges is they have life tenure. The framers tried to remove them from the political process. The whole idea was to have a body of judges free from political considerations. And the idea of disobeying a court order, boy, that's a constitutional crisis. I mean,
it is a constitutional crisis.
That's terrifying.
Yes, it is terrifying. In May of 2024, Donald Trump was found guilty of 34 felony charges under New York state law for falsifying business records to conceal hush money payments made to Stormy Daniels. Republicans believe that this prosecution was politically motivated and corrupt, but they seem to forget about the role of a citizen jury, which came to the ultimate unanimous conclusion of Donald Trump's guilt after hearing both defense and prosecution lay out the arguments. Can you just remind us why the Founding Fathers actually adopted the jury system? 1 or 2 sentences, if you can.
That's hard.
I know it's tough for a law professor.
I mean, that was kind of the genius of the framers, right? To put front and center ordinary citizens there, kind of to be safeguards against the government. I mean, to protect and be the decision makers, right? Prosecutors might be motivated to get the conviction, but to have the ultimate decision makers be people, ordinary people who are weighing the evidence and coming to decisions. That was kind of their genius.
It is genius, and there are even some checks and balances built into the system to make sure that jury members are impartial. What are 1 or 2 of those?
Well, I mean, you have challenges for cause. They're unlimited, typically, in every state. And peremptories, though there are some limits on those, but there's voir dire. I mean, that whole... sequestration, typically judges are kept from things, or rather jurors are kept from things that might prejudice them. Judges obviously have the ability to call a mistrial in the event that there's anything.
So there's lots of things built in to make sure that this is a fair process, and there was no evidence of improper bias or behavior by any members of the jury, right, in that criminal case.
No.
And once again, to confirm, did the citizen jury, this genius system that you've described, unanimously conclude that Donald Trump was guilty of 34 felony charges?
With respect to each of 34 charges.
Each one. So I want to turn to this legislative proposal which seeks to amend federal law to allow presidents to remove cases against them from federal court to state court. Under existing law, removal is only granted in limited cases, and motions have to be made on specific grounds that allow for removal. And one of those grounds is that a federal officer, member of Congress, or judge can remove a case if the case relates to, quote, any act under color of office. And the Supreme Court, as you've mentioned, has interpreted color of office to mean acts in performance of an official duty. The other side's legislation exceeds this requirement by allowing presidents to remove any case to federal court for any act in office, that's a quote from their legislation, regardless of whether it relates to exercising their official powers. Why is it a bad idea to eliminate that, quote, color of office requirement?
Well, I mean, you're certainly expanding the possible pool. Now, again, always qualified by the MESA federal defense, but you're expanding the possible pool of people who can take this bridge to federal court. I mean, I'm a federalism person, and I believe that having 2 sovereigns in our system, states and the federal government, is a protection against tyranny. I mean, the framers really thought about this, and that protects individual rights, and it to take from states their ability to prosecute violations of state law in their own courts is very intrusive. And the more that's allowed, I mean, that's a problem in our system.
Protection against tyranny, that's really what we're talking about here, and I really appreciate your input, and I yield back, Mr. Chairman.
I recognize the gentleman from Texas for 5 minutes.